Hello, everyone. Welcome along to the Public Trustee and Palliative Care Dying to Know Day webinar. We're going to be discussing documents to support your advanced care and estate planning decisions. So, very important topics today. So, I'd like to start by acknowledging the Tasmanian Aboriginal people, the traditional custodians of the land which we gather today, and I pay my respects to elders past and present. I'd also like to extend that respect to any Aboriginal clients or people who are with us today. So I am Maria. I'm the Marketing and Business Development Manager at the Public Trustee, and we are joined by Naomi Fu, who is our solicitor at the Public Trustee based here in Hobart. And we also have Kate Glover, who is the Sector and Community Engagement Officer at Palliative Care. Today is just general advice. We're not going into anyone's personal circumstances, so please make sure you get tailored advice to your situation, and don't sort of necessarily rely on what we're speaking about, because it is just general in nature. So we are going to be discussing estate planning and advanced care decisions that you need to think about. So the time and energy you spent on making estate planning decisions today will help ease the burden for loved ones and give them peace of mind. Now, what we are discussing today can be a bit challenging for some people, so please take care. We are talking about end of life decisions, so feel free just to be kind to yourself and sort of take the time as you need it. All right, well, I'm going to pass you on to Naomi. She's going to talk about the importance of estate planning and also give you a bit of a background about the Public Trustee and what we do.
As Maria's obviously alluded to, the importance of estate planning cannot be understated. It's obviously very important to have these conversations, and not only gives you peace of mind knowing that your loved ones are well aware of what your expectations and wishes are, plan to follow through. So it gives your loved ones peace of mind during a difficult time. And let's be honest, the last thing you want is obviously for your loved ones to dispute over or fight over who gets to make certain decisions for you, and who gets to inherit the whole or part of your estate or your assets. So what we'll be doing today is we'll be discussing legal documents you would need in terms of the management of your medical, financial, and or legal affairs, if and when you become unwell and cannot make decisions on your own. We'll also be discussing a legal document which would allow you to set out how you'd like your assets to be distributed after you've passed away. Now, advanced care and estate planning provides obviously peace of mind knowing that if something would happen to you, your loved ones, your life choices, as well as your estate plan will be looked after in the way that you would prefer. Unfortunately, without an estate plan in place, obviously a court or a tribunal may need to appoint someone else to make those decisions on your behalf. And the good news is with this advanced care and estate planning, well, it isn't a daunting process, or it's a never-ending process. It's sort of like an insurance policy that only kicks in when you sort of need it. So just to give you, a rough outline of the documents that we'll be discussing today, we'll obviously discuss about the Advanced Care Directive. This document essentially allows you to document your wishes and preferences in relation to your healthcare for when there comes a time when you are unable to communicate those wishes and preferences in relation to your healthcare yourself. We'll also be touching on a legal document called an enduring guardianship. This document essentially allows you to nominate or name a person or multiple persons to make personal and or medical decisions on your behalf if and when you are incapacitated. And then we'll be touching on another document called an enduring power of attorney. This document, on the other hand, allows you to nominate a person to manage your financial and or legal affairs. And lastly, we'll be touching on a legal document called a will, which I'm sure most of you are aware of. A will essentially allows you to obviously set up how you'd like your assets or estate to be distributed after you've passed away. Now, just before I hand it over to Kate to discuss what advanced care directives are and the work that palliative care does, what I'd like to do is just to briefly discuss the role of the public trustee. So the public trustee is a government business enterprise that provides obviously vital services to the Tasmanian community. We're established in 1915. We Public Trustee provides a range of free, subsidized, and or fee-based community services for Tasmanians, taking the form of wills, estate planning services, as well as trustee services to generations of Tasmanians. So obviously we provide and give trusted advice when you need to make your will. We also provide service to have enduring powers of attorney as well as enduring guardianship documents. We don't, however, offer the service to prepare advanced care directives. We do administer deceased estates when we have been appointed as the executor of a will, and under certain circumstances, the public trustee may take on the role of an executor of a will, say if a private executor decides to renounce their role to the public trustee. Public trustee also acts as a trustee for various types of trusts, including accident compensation awards or criminal injuries. The public trustee also manages funds that are under our control. And more recently, in the last 20 to 25 years, the public trustee have been supporting people who have impaired decision-making abilities, owing to an accident or illness, with the management of their financial and their legal affairs. So if a person ever needs support and does not have family or friends who can support them in terms of their financial affairs, public trustee can be appointed as an administrator by the Tasmanian Civil Administrative Tribunal. So that's pretty much what I'd like to discuss about the role of the public trustee. Kate, can you now explain what palliative care does and what an advanced care directive is, and why do we need one?
Good morning, everyone, and welcome to our Advanced Care Directive session. My name is Kate, and I'm here representing Palliative Care today. And thank you to the Public Trustee for organising this event. As we know, each August we acknowledge Dying to Know Day, which is an annual event held on August 8th, which is part of the public health campaign aimed at encouraging Australians to engage in conversations about death, dying and grief. Today, I'd like to acknowledge the original owners and custodians of this beautiful island of Lutruwita, Tasmania. Lutruwita is rich in cultural heritage, and the Palliative people have walked this country for thousands of years and continue to have a deep connection to the land today. At Palliative Care Tasmania, we acknowledge the Palliative people's deep connection to family and community and their enduring strength and compassion in caring for their death, the dying, sick and grieving. Just also a note for today, the information provided is general in nature, and please seek professional health advice for further information. So Palliative Care Tasmania is a peak body for palliative and end-of-life care. We work collaboratively with our members and sector to ensure that all Tasmanians have quality, equitable and compassionate access to the support they need. 75% of Australians have not had end-of-life discussions. Talking about death and dying is difficult for many of us, and yet we know if we engage in these conversations, especially if we are living with a life-limiting illness, then we can ensure our wishes are respected and have better healthcare outcomes. Our families have better grief and bereavement outcomes, less stress, worry, and we will avoid treatments that we will not want. We need to start breaking down these stigmas associated with talking about some of these difficult and awkward topics and create better death literate communities so we can care for one another through life, through death and grief. Now, to explore what matters most to you, we'll watch this short film from Advanced Care Planning Australia, Love is Not Enough. As you can see there, up to 50% of people don't have a chance to have those end-of-life discussions. So the benefits of planning ahead is that it ensures preferences are known and followed. It eases stress for family members. It helps healthcare professionals avoid unnecessary or unwanted treatment, and it improves grief outcomes for families. So what is advanced care planning? Advanced care planning involves planning for your future healthcare. It is voluntary and it's for anyone of any age, but it especially becomes more important for those that may be at risk of losing their decision-making ability, are older, have multiple diseases or illnesses, developing dementia, are approaching the end of life, or living alone. Advanced care planning should happen when you are well, before there is a sudden need for decisions to be made. Ideally, advanced care planning will result in your preferences being documented into a plan known as an advanced care directive. So what is an advanced care directive, an ACD? So making an advanced care directive allows you to set out or guide what health care treatment you wish to receive in the future if you lose the ability to make or communicate such preferences and decisions yourself. You can include in your advanced care directive information about your values, your preferences, what can guide a person making a decision about your healthcare, and specific treatments you refuse and in what circumstances. The ACD helps health practitioners and others understand what's important to you and what to choose for you. It's a legal written document. As discussed, you can give specific instructions about certain medical treatments you do or do not want, your values and preferences. The ACD, so the Advanced Care Directive, only comes into effect if you do not have decision-making ability or are unable to communicate your preferences. A completed Advanced Care Directive can be registered with the Tasmanian Civil and Administrative Tribunal, TASCAT, and an Advanced Care Directive must be written in English. The directive will only operate when the person has impaired decision-making ability in relation to a healthcare decision, and the direction consenting to or refusing healthcare is clear and unambiguous. Under the legislation, if someone has lost decision-making ability, they cannot complete the ACD. And remember, the goal isn't for everyone to have a legally binding ACD, but rather enable your patients who are elderly living with a life-limiting illness to have an early opportunity to learn about advanced care planning and consider their preferences. The most important thing are the conversations. Thank you.
Thanks so much for that, Kate. Naomi, maybe you'd like to now talk to us about wills, enduring powers of attorney and enduring guardianships.
So, as previously mentioned, advanced care and estate planning is an important aspect of providing protection and support not only for yourself, but also more important for your loved ones. In the event if something were to happen to you where you no longer have the ability to make healthcare, financial, and or legal decisions on your own. So to ensure that you have the right plan that meets your needs, as well as the specific needs of your loved ones, it is recommended that you obtain professional assistance to prepare or have these legal documents prepared for you. To give you some context as to the relevance and importance of having an enduring power of attorney document in place, you may first wish to consider these questions. Who would you prefer and entrust to look after your monies in your bank accounts? Say if you suddenly had an accident or become unwell, do you have someone that you prefer not to have access to your financial monies in your bank accounts or make financial decisions on your behalf? Now, an enduring power of attorney document essentially allows you to nominate or name a trusted individual or multiple individuals, such as a spouse or a loved one, or an organization such as the public trustee. So we call this person your attorney. Your attorney essentially looks after your financial and or legal affairs during your lifetime, either when you instruct them to do so or when you no longer retain that decision-making capacity anymore. Now, without this document, the control of your financial and or legal affairs, they're not automatically assigned to your spouse or loved ones, and therefore, your loved ones may be left without the ability to operate your financial affairs. They may not be able to pay bills on your behalf, sell your property, or deal with your financial and or legal affairs however they see fit and appropriate. Now, an enduring power of attorney document needs to be registered with the Land Titles Office. So you may wish to get it registered in advance or until a need arises for your attorneys to look after your financial and or legal affairs. Now, until a need arises for your enduring power of attorney to take effect, you obviously will maintain independent financial control over your own affairs, at which point you can have peace of mind knowing that in your time of need, your financial and or legal affairs are managed by persons you entrust to do so on your behalf. Now, unless you are declared bankrupt, an enduring power of attorney document only operates during your lifetime and automatically ceases once you passed away. Before you nominate or appoint anyone to act as your attorney, you should carefully think about who you entrust to obviously look after your financial affairs on your behalf. The role of an attorney is obviously quite a demanding job filled with wide-ranging responsibilities. It requires a good working knowledge of legal, business, financial, and or investment matters. And in some circumstances, it may be unreasonable to ask a friend or relative to take on this role, and as such, in those circumstances, it may be ideal to nominate an impartial or independent person or party to act on your behalf, such as the public trustee. Now, moving on to another estate planning document, an enduring guardianship. So, say if you suddenly become unwell or have been involved in an accident, you may not be able to obviously communicate your wishes and/or preferences as to your healthcare and/or lifestyle related affairs. This may, of course, include what sort of medical treatment you'd like to receive, whether you'd like to live in your own home or in a nursing facility, who can visit you, and what sort of personal services you would prefer to receive, such as home support, for example. Now, an enduring guardianship document essentially allows you to nominate or appoint an individual or multiple individuals to act together to make personal and/or healthcare decisions on your behalf when you no longer retain the decision-making ability. Now, obviously, we call this person your guardian. You can, of course, nominate a sole guardian or multiple guardians to act on your behalf, as well as a substitute or backup guardian to make decisions on your behalf in circumstances where the original guardians are absent or incapacitated and is therefore unable to act for you. This document is obviously especially important if you have specific wishes about your healthcare and preferred persons you wish to name to make those medical and/or personal decisions on your behalf. Now, when appointing a guardian, they must obviously be an adult. They must be over 18 years of age. They cannot be a person who is involved in an administrative or professional capacity in your medical care or treatment. Take, for example, your general practitioner. So obviously you can't nominate persons as such. You also cannot nominate the public guardian or public trustee to act as your enduring guardian. Now, your enduring guardian essentially should be someone you trust and who knows your wishes and preferences as to what sort of healthcare or medical treatment you'd like to receive. There should preferably be a person who is decisive and able to advocate on your behalf to medical staff, care providers, and/or members of your family. Now, your enduring guardianship document must be registered to have legal effect. This registration process occurs at Service TAS. Now, an enduring guardianship document only comes into effect if and when you've lost the decision-making ability. So hopefully, the hope is you never need that document. It may never become operational. However, if an unwanted medical emergency arises, you can have peace of mind knowing that you have appointed a person or multiple persons to advocate for you, your wishes that relate to your medical and/or lifestyle preferences. Now, more importantly, I'm sure most of you would like to know what would happen, say, if you were to lose decision-making ability but have not appointed an attorney and/or a guardian. So say if you were to lose your decision-making ability, you have not appointed an enduring guardian, decisions about your medical and/or dental treatment may be made on your behalf by a person responsible. Now, what a person responsible is may differ depending on your personal circumstances. It may be your spouse or someone with whom you are in a close and continuing relationship with. If no one springs to mind and no one falls within that definition, it then reverts to an unpaid carer who is providing support to you. And say if you do not have a carer at that point in time, that person responsible would be a close relative or a friend who has a close personal relationship with you through either frequent personal contact and who has a personal interest in your welfare. Now, this could of course include a child or even your next door neighbor. So as you can probably appreciate, this person responsible default system may in some circumstances not reflect your preferences as to who you would like or prefer to make medical decisions on your behalf. Now, in circumstances where a person responsible does not wish to make or consent to medical treatment on your behalf, the Tasmanian Civil and Administrative Tribunal may be called upon to make a determination. Now, the tribunal may then, appoint the Office of the Public Guardian to make medical and/or personal decisions, medical decisions on your behalf. So that's in the context of, medical decisions. Now, say if you do not have an appointed attorney, and for example, if, your loved ones need to access your bank accounts to manage your financial affairs for you, or in the worst case scenario, say should there be a dispute as to who should have access to your bank accounts or who should look after your financial and/or legal affairs on your behalf. Likewise, the Tasmanian Civil and Administrative Tribunal may be called upon to help at that point in time. So they'll hold a hearing, and in most cases they will appoint a family member or a friend to assist. Now, say if there is no one to help or no one suitable that the tribunal thinks who should look after your financial affairs, the public trustee may then be appointed to support persons who obviously do not have an appointed attorney. So as you can probably appreciate, in some cases, both the public trustee and the office of the public guardian may be appointed to support a person with the management of their financial and/or legal affairs, as well as their, personal and/or medical related affairs. So that's the enduring power of attorney and enduring guardianship documents covered. What I'd now like to do is just essentially to talk about a will. So obviously, when you pass away, your will pretty much specifies how you'd like your assets and/or property to be distributed. Your will's pretty much your voice after you've passed away. See, with a will, you can set up your expectations as to how you'd like your assets to be distributed and who you would like to inherit your assets. Your loved ones obviously will be provided for and be able to grieve in as healthy a way possible without, hopefully any fights amongst family members or loved ones as to who should, inherit your assets. Now, as part of your will, you would need to nominate a trustworthy individual or multiple individuals or even an independent organization to be responsible for carrying out your wishes in your will, such as the sale of your property and the actual distribution of your assets. So we call this person your executor. The importance of having a professionally written and up-to-date will cannot be understated. To name a few reasons as to why it's important to have a will, it of course ensures that the right persons are provided for when you pass away. It enables your assets to be distributed according to your own wishes and preferences. It minimizes disagreements amongst those who expect to benefit from your estate. It also assists those who are responsible for managing your estate to understand how you would like or prefer to have your estate to be managed. And obviously, it enables your estate to be administered as efficiently as possible. Now, even if you do not think you have many assets, it's probably advisable to still have a will and documented plans in regards to how you'd like your assets to be distributed, especially in circumstances where you've got assets of sentimental value that you'd like to leave to specific family members or specific persons. Take for example, if you have pets, obviously you may wish to consider who you'd like to leave the care of those pets to. So the importance of having a will and keeping it up to date cannot be understated. So we obviously strongly recommend that you seek professional advice when you have your estate planning documents, your will, enduring power of attorney, as well as enduring guardianship documents prepared. You may wish to have these documents prepared with a solicitor, or you could also have them prepared with the public trustee. I'm sure everyone has probably heard of, do-it-yourself wills or will kits. While it may seem that it may be convenient to write your own will, doing so may be problematic, and what's worse is obviously when you go and write your will, issues regarding the validity of your will may only present themselves after the person who has wrote the will has passed away. So to paint a picture, say if a will is not prepared correctly, it may end up costing more to rectify any issues that relate to the validity of the will or the actual administration of the estate, which in effect may create even bigger emotional toll on your loved ones. Now, if you do decide to have your estate planning documents prepared with the public trustee, your will document prepared with the public trustee, you have the option or choice of appointing a family member or friend to take on the role of an executor, so to manage your distribute your assets. Now, if you do not want to burden your family or want someone impartial to deal with the administration of your estate, you also do have the option of appointing the public trustee as your executor. If a person passes away without a will, that person's essentially passing or die intestate. So at that point in time, the intestacy laws would then determine how that person's estate is distributed. This may of course mean that the estate may not be distributed according to the deceased person's wishes. At that point in time as well, an application needs to be made to a court to seek an order to appoint an administrator of the estate. So in Tasmania, the distribution, it's made according to a formula laid out in the Intestacy Act 2010. So essentially that formula sets out who obtains priority in terms of the actual inheritance of and assets of a person who has passed away intestate. So as you can probably imagine, a distribution determined in that way may create significant problems. So for instance, assets or estate may pass to a relative who had little or nothing to do with the deceased person. Obviously, this is why dying without a will can be problematic, as your estates may not be distributed to loved ones who are probably closest and most important to you. It can also cause delay and additional expense if those left behind argue as to who should be appointed to act as the administrator of the estate, and whether or not the intestate distribution actually adequately provides for those people who are closest to the deceased person. That's pretty much all I want to say about a will. I'll hand it back to Maria.
Thank you so much, Naomi, and thank you also to Kate. That's a lot of information that we've covered today, and I really hope that that's been really useful for people to understand the importance of preparing those documents. And I really hope that today's, the main takeaway is that your legacy matters, and it's important to make sure that your wishes are documented just to protect your loved ones. One size doesn't fit all when it comes to estate planning, so you do need to make sure that your plan is suited to your needs, and to ensure that, your wishes are understood by your loved ones.